Dr. Warren, I'd like to talk to you a little bit about the wiretap transcript that you reviewed. Now, you told us that this was a conversation between Chase Covington and Avery Bancroft, right?
Yes, sir.
And no one else was involved in this call.
Yes, sir.
So as far as you can tell, this was a private call, wasn't it?
Yes, sir, it was.
So both of them would have been talking to each other and no one else.
Yes, sir. It was a call by Avery placed by Avery excuse me, I'm so sorry. A call placed by Avery Bancroft to Chase Covington.
Now, when you were talking about the things Avery Bancroft said, you used the word potential bribes, isn't that right?
Yes, sir, I did.
Now, nowhere in this transcript does Avery Bancroft ever use the word bribe, does she?
No, the word bribe is never explicitly stated.
And in fact, Chase Covington never says it either, correct?
No.
And in fact, Avery Bancroft only actually mentions money one time, right?
Yes.
She says cash on hand. Those were the words she used?
Yes, she said, I'm looking at my cash on hand. I'm looking at how much I can put down.
She's looking at how much she can put down. Does she ever say what she'd be putting it down for?
No. A specific purpose for the cash is not explicitly stated.
So it's entirely possible that this could have been an initial investment in the casino, couldn't it have been?
Based on what I reviewed.
Objection, speculation.
Any response?
Yes, Your Honor. The question was whether or not it's possible that this could be talking about investment. Now, Dr. Warren is a linguistic analyst, and he's able to look at conversational patterns, look at the words used, and tell us what it might mean and what it indicates about the conversation. So he's capable of looking at the language used and saying whether or not what the cash on hand was specified, and whether or not possibilities were specified. He can tell us whether or not Avery Bancroft narrowed down the options for what this cash was, and whether or not a startup investment was within the realm of possibility based on the language Avery Bancroft used.
Any response to that?
Yes, Your Honor. Now, that statement taken out of context can mean any type of possibility, Your Honor. And furthermore, this witness has already explained on direct examination that when she said, I'm looking at the cash on hand, she made sure that she was only talking about Covington. And after reviewing the deposition of Ms. Bancroft, he realized that she then bribed Chase Covington with actual cash, Your Honor. He has already laid the foundation that that's what she was referring to, Your Honor. So therefore, going into all the possibilities that she could have meant is speculation.
For now, at least, it's crossed. So I'll give him some leeway here. We'll see if he takes it too far, though. And if you think he does, then you can re-raise your objection.
Yes, Your Honor.
Go ahead.
So it's entirely possible that Avery Bancroft could have been referring to a startup investment, right?
Well, if the statement is taken out of context, yes. But for the entirety of the conversation, it is clear that this is a reference to the means that Avery Bancroft will use to bribe.
But Avery Bancroft never actually offers anything to Chase Covington in this whole conversation, does she?
No.
Nowhere in this conversation does she say she's going to give anything to Chase Covington, does she?
No, not explicitly, no.
So we have no way of knowing whether or not that money was actually meant for Chase Covington or not, do we? Not for this conversation.
Well, based on what I reviewed, the statement that we're talking about was a reference that was used to the means that Avery Bancroft would use to bribe Chase Covington.
Well, right, but from this conversation, we don't know that that money is a bribe, do we?
Not explicitly, no.
And you also told us that you reviewed some emails that were sent back and forth between Corey Hyde and Mick McKean, isn't that right?
Yes, sir.
Would you recognize a copy of them if I showed you today?
Yes, sir.
Permission to approach opposing counsel with what's been marked Defense Exhibit B.
You may.
First approach witness the same.
Yes.
And would Your Honor like a courtesy copy?
Yes, please. Thank you.
Now this is one of the documents that you analyzed as part of your investigation, isn't it?
Yes, sir.
So you would have analyzed the language patterns used by both of the people in this conversation?
Yes, sir.
You would have analyzed the specific words they used and what it might mean?
Yes, sir.
And is this a fair and accurate copy of the emails you reviewed?
Yes, sir.
Your Honor, at this time I move to admit Defense Exhibit B into evidence.
Your Honor, at this time I would object to hearsay.
Okay. Any response?
This is hearsay, Your Honor, but it's admissible under Rule 703. Now, Rule 703 states that expert witnesses may rely upon and disclose to the jury testimony and other evidence that would be otherwise inadmissible in order to form their expert conclusions. Now, specifically, this is an email that Dr. Warren analyzed in order to come to his conclusions. He's told us that he analyzed the specific language and the specific words used in order to come to conclusions about what that might mean in terms of the investigation. So it's essential that the jury hear not only his conclusions, but the specific words and phrases he analyzed to come to them. Without that information, they can't understand his conclusions, and so this is essential for his conclusions, and it needs to be published to the jury. Thus, it's qualified under Rule 703 as admissible hearsay.
Okay, what's your response to that?
Your Honor, this witness has received this to come to his conclusion, but according to Millen's case law, Richards versus Mississippi Barbecue, this witness cannot simply be a conduit to hearsay. Your Honor, prior to your previous ruling on this document, Your Honor, that it wasn't admissible, they are trying to use this through this witness to get it in, Your Honor, and simply being a conduit to hearsay, Your Honor, as he has already came to his conclusion and therefore has talked about his conclusion on March 31st that he followed the best practices. Therefore, this documentation is not, this documentation is going to be he's simply going to be a conduit to hearsay to get this document in, which you have already previously ruled on, Your Honor.
Okay. What's your response to that?
Well, as for the issue of whether or not Dr. Warren has whether or not best practices were actually followed, that's an issue for the jury to decide, and so we don't necessarily know that they were practiced, and we contend that they weren't. As to the reliance on this specific document, this is not being a conduit to hearsay. Mississippi Barbecue v. Richards specifies that there's a distinction between being a conduit to hearsay and admitting evidence that the expert relied upon in order to come to their conclusions, and this falls into the latter category. This is evidence that the expert relied upon, he analyzed to come to his conclusions, and furthermore, it's evidence that the jury needs to hear to understand those conclusions. If he tells us that certain steps were or weren't followed in an investigation based on words and phrases analyzed, we need to know what those words and phrases were in order to understand his conclusions. It's qualified under Rule 703 as admissible hearsay. If that witness is not being a conduit to hearsay, and this is admissible.
Can you proffer what his conclusion is based on this?
Yes, Your Honor. Now, this witness can testify that this was an example of Detective Keenan telling Corey High to say certain things in the meeting, things that we can show were later said in the March 31st meeting. He'll tell us that this is a textbook example of what's called coaching, which can often be a sign of entrapment and an indication that best practices might not have been followed.
Okay, it's your objection. I'll give you the last word.
Your Honor, for Mississippi, Richards versus Mississippi Barbecue, for this document to be allowed, Your Honor, he has to have this documentation be based upon his conclusion. We have heard his conclusion in today's case, Your Honor, and that was not his conclusion. So therefore, he is being a conduit to hearsay.
If I may respond very briefly on those grounds, Your Honor.
No, that's okay. Do you contend that he did not draw any conclusions based on this document?
I'm not contending that, Your Honor. I'm just saying that he did get his conclusion today, and that was not one of his conclusions that he elicited.
Okay, well, I think if he did draw a conclusion based on it, simply because you didn't bring it up doesn't necessarily preclude counsel from bringing up perhaps contrary conclusion or a conclusion to weigh against the ones that you did bring up. So along those lines, I will admit the document
Yes.
under that exception, or
Yes.
that rule.
Yes, Your Honor.
Yes, Your Honor. Dr. Warren, one of the things that Mickey Keenan tells Corey High is that he should suggest something to Avery Bancroft, doesn't he?
Yes, subtle hint dropping, yes.
And he specifically uses the word, you should say, you need to offer to sweeten the pot. Isn't that the language used?
Exact language, yes.
And when you reviewed the March 31st transcript, Corey Hyde used those exact words, didn't he?
Yes, he did.
And you'd agree that that's a textbook example of what's called coaching, isn't it?
While this email is an example of textbook coaching, the informant is part of the investigation. The informant must be informed in order to maintain the integrity of the operation.
But nonetheless, this is an example of what you would call coaching.
Objection,
isn't it?
yes, and answer.
I'll give him this one last one to just sort of clarify the answer.
Yes, Your Honor.
Just to clarify, Dr. Warren, this is an example, it's a textbook example of what's called coaching. Isn't that right?
Yes.
And coaching was one of the things that you identified as being sometimes a sign that entrapment might have occurred.
Well, it is definitely one of the strategies that should be used very minimally, so not to induce suspects into criminal activity. I apologize.
So if it is overused, then it would be indicative of entrapment, would it not?
Typically, overuse of any of the conversational strategies, any excessive use has been known to induce.
Objection, Your Honor, to out of the scope of the witness's expertise. When this attorney just asked him about whether or not it would go into entrapment, Your Honor, this witness does not have the legal background to say whether or not Avery Bancroft was entrapped or it would go to entrapment, Your Honor.
Okay, response?
No, I would agree with the opposing counsel that this witness can't make the definitive legal conclusion that entrapment did or did not occur. That's certainly a question the jury and only the jury can decide. However, this witness can tell us whether or not certain behaviors are signs of entrapment, whether or not certain behaviors have been associated with entrapment in the past and so may indicate that entrapment is present. That's not the same as telling us that entrapment did or did not occur, but he is capable of telling us whether certain types of speech and certain strategies by the police are indicative of entrapment and often occur when entrapment is present. He's very qualified to tell us that, and it's certainly within the bounds of his expertise to say so.
Okay, last word.
Your Honor, entrapment is a legal term, Your Honor. He does not have a legal background, therefore he cannot tell us. And differentiation, trying to say that he can tell us that if the police officers were trying to entrap Ms. Bancroft is going out of his expertise, Your Honor.
I agree that he can't tell us whether or not the defendant was entrapped. I guess I'll sort of split the baby here. Let's just use a different word than entrapment. Stick with something along those lines, but not the actual legal term.
Yes, Your Honor.
All right.
Yes, Your Honor.
You'd agree that if coaching the witness is overused then, that can be indicative that criminal activity is being induced.
Yes, that's correct.
Your Honor, permission to approach the witness to retrieve defendant's seat.
You may.
And would Your Honor like the identified copy?
No, thank you. We'll keep the courtesy copy.
And I finally wanted to ask you a few things about March 31st. Now, one of the things you mentioned on direct examination was this idea of dropping hints of bribery. Isn't that right?
Yes.
So then Avery Bancroft could latch on to them if she was interested, right?
Yes.
Now, you also would agree that these hints have to be at least somewhat clear about what they're offering. Isn't that right?
Yes, the hint should be clear, so the suspect latches on, yes.
Avery Bancroft would have to know what it is she's agreeing to, right?
Typically, yes.
And if those hints are clear, if they use ambiguous language, that can be another sign that inducement of criminal activity occurred, can it?
Well, the language has to be clear so that the suspect understands and comprehends what's going on, yes.
And so, just to clarify, if the language isn't clear, if it's instead ambiguous, then there's a very good chance that the suspect wouldn't understand, right?
Yes, excessive use, yes.
And if they don't understand what's going on, then they could be induced into criminal activity, couldn't they?
Typically, possible, yes.
Now, one of the statements you'd mentioned was here on line 46 and 47. It's on the second page. Now, Mickey Keenan said, you have to go the extra mile, right?
Yes.
No, clearly he probably wasn't asking Avery Bancroft to go run a mile, right?
No.
But he never actually says what he means by the extra mile.
No, it's not clarified.
So he never actually says what he's looking for Avery Bancroft to do.
No, not explicitly, no.
And then later on, in line 60, he says, you'll need to pitch more than ideas. Isn't that right?
Yes.
Does he ever say what else he wants her to pitch?
Well, no, it's a hint. That's for the suspect to pick up on and latch on to.
But it's left ambiguous, isn't it, as to what else he wants her to do?
Well, more than ideas.
but do we know what more it is?
No, it's not explicitly stated.
And there's a final thing that you talked about in your report, and that's this idea of ignoring unwilling conduct. Now, if the suspect is unwilling to do something, please just ignore it. That can be a very clear sign of inducement criminal activity, right?
Excessively used, yes.
No, the excessive use, that's really important, because right here on line 31, Detective Keenan asks, why should we let you have 2 casino licenses, right?
Yes.
Maybe Bancroft says, well, because I'm the best. Isn't that right?
Yes.
And so then Hyde jumps in and says, well, no, I think they want to know whether you'll do anything to sweeten the pot, correct?
Yes.
And Bancroft says, oh, well, I could have conference space, right?
Yes.
And Keenan says, let's try this again. What are you willing to do to make this happen?
Yes.
And Avery Bancroft tells him, well, I know I've got the best proposal. I'm an experienced casino owner. My casino brings in millions of dollars in tourism to the state. This casino would be great for me and all of Midlands. She talks about what she's willing to do, right?
Yes.
Talks about her business plan.
Yes.
So 3 times she was asked what she'd do to get this casino.
Yes.
And 3 times she talked about her business plan, didn't she?
Yes.
But then Mickey Keenan responded, you know that's not what I meant. Here in Midlands, it's not enough to have a good business plan. That's what he said.
Yes.
You told us on direct examination that after everything else fails, the most important thing to do is ask a clear, unambiguous question to see if Avery Bancroft would be willing to offer a bribe.
Yes.
Could you please point out in that document where Detective Keenan asks a clear, unambiguous question if Avery Bancroft would be willing to bribe Chase Covington? He never asks her, does he?
Officer Keenan asked, what are you willing to do to make this happen?
But he doesn't ask a clear, unambiguous question, does he?
It's pretty clear.
It isn't clear about bribery, is it?
No, it doesn't mention bribery at all.
So he never asked a clear, unambiguous question about bribery. the crime
About
of
bribery, no.
No further questions, Your Honor. Permission to approach the witness, retrieve documents, and turn to the bench.
You may.